Good afternoon. Welcome back to Passionate World Talk Radio Network, a wholly owned subsidiary of Global Media Network, LLC. Educate, enlighten, entertain, mindfulness. And to this episode of the U.S. Constitution, its articles, we're also going to be talking this afternoon about the Bill of Rights. What is the Bill of Rights, and why do we have the Bill of Rights? Well, to start out with, the call for the Bill of Rights was the anti-federalist Constitution and also its most powerful weapon. They weren't too happy with the Constitution because of its vagueness and lack of specific protection against tyranny. So Patrick Henry asked the Virginia Convention, what can avail your spacious, meaning large, imaginary, something you think up of, your rope dancing, meaning that you all cannot agree on one thing. So let's try to get this together, gentlemen. Chain rattling. Well, if you hear a chain rattle, you know it squeaks. Ridiculous ideal checks. He wasn't happy about the checks and balances being put on the government. And contrivances, meaning making up things that prevent it from coming through. So the anti-federalists demanded a more concise constitution, one that laid out for everyone to see the rights of the people and the limitations of the new government, and claimed that the shortness of the document only revealed its inferior nature. Richard Henry despaired at the lack of provisions to protect, quote, their essential rights and to protect those rights without which liberty cannot exist. And he wanted to trade in the old government, which were kings and emperors, for a new government. And Lee argued, you be trading one for the other. At the Philadelphia Convention, the Bill of Rights was hardly mentioned. Most delegates held that the fundamental rights of individuals had been secured in the state constitution. James Wilson maintained that a Bill of Rights was superfluous, meaning we don't really need it, guys, because all power not expressly dedicated to the new government was reserved to the people. However, it was clear that this argument that the anti-federalists held, they held the upper hand, meaning something was going to get done about it. Even Thomas Jefferson, generally in favor of the new government, wrote to Madison that a Bill of Rights was, quote, what the people are entitled to against every government on earth, end of quote. So by the fall of 1788, Madison convinced that not only was a Bill of Rights necessary to ensure the acceptance of the Constitution, but it would have positive effects. He wrote on October 17, quote, fundamental maxims of free government, unquote, would be, quote, a good ground for an appeal to the sense of community, unquote, against potential oppression and, quote, counteract the impulses of interest and passion. Something must have gone wrong in the 21st century, folks. Madison's support of the Bill of Rights was of critical significance. One of the new representatives from Virginia to the first federal Congress, as established by the new Constitution, he worked tirelessly, meaning without a break, to persuade the House to enact amendments, diffusing the anti-federalist objections to the Constitution. Madison was able to shepherd, meaning to guide it through, and have each one of the articles, amendments, adopted by 1791. 3/4 of the states had ratified the 10 amendments, now so familiar to Americans as the Bill of Rights. Benjamin Franklin told a French correspondent in 1788 that the formation of a new government had been like a game of dice. You took your chances. With many players of diverse prejudices and interests unable to make any uncontested moves. Madison wrote to Jefferson that the welding of these clashing interests was, quote, a task more difficult that can be well conceived by those who were not concerned in the execution of it, end of quote. When the delegates left Philadelphia after the convention, few, if any, were convinced that the Constitution that they had approved outlined the ideal form of government for the country. But late in his life, James Madison scrawled out another letter, one never addressed. In it, he declared that no government can be perfect and, quote, that which is the least imperfect is therefore the best government, end of quote. Well, that's not quite true either. The fate of the U.S. Constitution after its signing on September 17, 1787, can be contrasted sharply to the travels and physical abuse of America's other great parchment, the Declaration of Independence. As the Continental Congress during the years of the Revolutionary War went from town to town, the rolled-up declaration was carried along. After the formation of the new government under the Constitution, the one-page declaration, eminently suited for display purposes, graced the walls of various government buildings in Washington, exposing it to prolonged damaging sunlight. It was also subjected to the work of the early calligraphers, those are the people who actually wrote it out, responding to a demand for reproductions of the revered document. As any visitor to the National Archives can readily observe, the early treatment of the now barely legible Declaration took a disastrous toll. The Constitution, in excellent physical condition after more than 200 years, has enjoyed a more serene, quiet life. The Constitution, by 1796, was in possession of the custody of the Department of State along with the Declaration, and traveled with the federal government from New York to Philadelphia to Washington. Both documents were secretly moved to Leesburg, Virginia, before the imminent attack by the British on Washington in 1814. After the war, the Constitution remained. That's the War of 1812, for those who don't know. After that, the Constitution remained in the State Department while the Declaration continued its travels to the Patent Office building from 1841 to 1876 to Independence Hall in Philadelphia during the centennial celebration, and back to Washington in 1877 to the Independence Hall in Philadelphia. And then on September 29, 1921, President Warren Harding issued an executive order transferring the Constitution and the Declaration to the Library of Congress for preservation and exhibition. The next day, Librarian of Congress Herbert Putnam, acting on the authority of Secretary of State Charles Evans Hughes, carried the Constitution and the Declaration in a Model T Ford truck to the library and placed them in his office safe until an appropriate exhibit area could be constructed. The documents were officially put on display at a ceremony in the library on February 28, 1924. On February 20th, 1933, at the laying of the cornerstone of the future National Archives building, President Herbert Hoover remarked, quote, there will be aggregated here the most sacred documents of our history, the originals of the Declaration of Independence and the Constitution of the United States, end of quote. The two documents, however, were not immediately transferred to the archives. During World War II, both were moved from the library to Fort Knox for protection and returned to the library in 1944. It was not until successful negotiations were completed between the Librarian of Congress, Luther Evans, and Archivist of the United States, Wayne Grover, that the transfer to the National Archives was finally accomplished by special direction of the Joint Congressional Committee on the Library. On December 13th, 1952, the Constitution and the Declaration were placed in helium-filled cases, enclosed in wooden crates, laid on mattresses in an armored Marine Corps personnel carrier, and escorted by ceremonial troops, 2 tanks, and 4 silvermen carrying submachine guns down Pennsylvania and Constitution Avenues to the National Archives. 2 days later, President Harry Truman declared at a formal ceremony in the Archives Exhibition Hall, quote, "We are engaged here today in a symbolic act. We are enshrining these documents to future ages. This magnificent hall has been constructed to exhibit them, and the vault beneath that we have built to protect them as safe from destruction as anything that the wit of modern man can devise. All this is an honorable effort based upon reverence for the great past, and our generation can take just pride in it." Well, so much for that. Now, let's take a look at the different articles. The first article has 10 sections on it. I believe we went through Article 1 and Article 2. So let's go over to Article 3. Article 3, Section 1. The judicial, which means the legal power of the United States, shall be invested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which should not be diminished during their continuance in office. So what they're telling you, folks, is that the Supreme Court is numero uno of law and legality in our America, and that lesser courts will be established to help them maintain this law and order. Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. So they're telling you that the Constitution has made these laws and these treaties, and that they are under their authority in all cases of admiralty and maritime jurisdiction, to all cases affecting ambassadors, other public ministers, and consuls. And that these controversies between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens are subject. So what they're telling you is that if you have a beef with another state, whether you live in that state or you're outside the state, doesn't matter. Everything is done under the Supreme Court's authority. In all cases affecting ambassador, other public minister, and consuls, and those in which state shall be a party, the Supreme Court shall have original jurisdiction, which means it's numero uno. Yes, the number one party. Everything goes down from the Supreme Court. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in case of impeachment, shall be by jury, and such trial should be held in the state where the said crimes shall have been committed, but when not committed within any state, the trial should be at such place or places as the Congress may, by law, have directed. Section 3. Treason against the United States shall consist only in leavening war against them or adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Meaning, if they're going to be punished and they have to pay something, it happens during their lifetime. Once they're dead, they're dead. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. So each state has the right to hold judicial proceeding, meaning courts of law, for things that are happening within their state. Murder, killing, rape, looting, whether you kill a parent or you kill a homeless person on the streets, all the same. Section 2. The citizens of each state with treason, felony, or another crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on the claim of the party to whom such service or labor may be due. Loosely translated, if a person kills, moves to another state, that other state has to return them should the original state ask them to return it. The same thing if they flee to another country, jurisdiction runs over, and Mexico will return it most of the time. Now, if that person flees to Europe or Asia, they may not yield. In other words, they may not extradite the person that's in their country. It's happened before where there are several countries overseas do not believe in a death penalty and therefore refuse to extradite the murderer in their own country. Section 3. New states may be admitted by the Congress into this union, but no state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without consent of the legislatures of the states concerned, as well as the Congress. I wonder if the Congress was asked about Canada and Greenland, or was that the cart after the horse? Section 4. The United States should guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. So, as every state in this union should remain a republican form of government, then why are we being attacked by our own government who refuses to recognize the United States as a republic and has turned it into something quite different than was envisioned by our former founders of the Declaration of Independence and the creation of the U.S. Constitution? Article 5. Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Suffrage meaning equal, men and women. Think about it. And we will stop and begin next time on Article 6 about debt. That means people you owe money to, credit unions, banks, loans, mortgages, a debt, your kid's allowance. That's a debt. Thank you very much for joining us this afternoon on Historical Lest We Forget with your host, Lillian Cauldwell. We're going over the articles of the Constitution, and before that, we spoke briefly about the Bill of Rights and how hard fought it was to get it included in our Constitution. This program is brought to you by Conscious Research Solutions. Have problems with research? Don't know where to begin? Go over to passionateworldtalkradio.com/Research Made Simple blog, and there it will answer all your questions about the pain points associated with research. And if you're interested or want to learn how to do it yourself, sign up for a free 15-minute consultation. And if you want to continue hearing the truth, the whole truth, and nothing but the truth, so help you to a piece of toilet paper, please go over to passionateworldtalkradio.com/donation, and please consider donating $5 to an all-woman-run, woman-owned station, or better, or higher, is just a suggested foundation upon which this radio station will keep on grooving to the tone. Thank you all very much for listening, and have an awesome weekend.